no balancing test, no deference to state tradition. A criminal law whose elements turn on the race of the defendant is, in Stewart's reading, simply not a law at all. Warren returned in the final paragraph of Part 2 to the Lovings themselves, to Mildred, to Richard, to the four words that had been waiting at the bottom of a 9-year journey through Virginia's courts. He wrote simply, "These convictions must be reversed." And then, in the formal closing of a Supreme Court opinion, the 3 words that make the judgment real. "It is so ordered." With those words, Mildred and Richard Loving were no longer felons. The 25-year banishment, signed by a Virginia judge invoking the geography of God's continents, was dead law. And the ruling reached further than the Lovings' front porch in Caroline County. In a footnote to the opinion, the court listed the 16 states that, at the moment of decision, still had anti-miscegenation statutes on the books: Virginia, Alabama, Arkansas, Delaware, Florida, Georgia, Kentucky, Louisiana, Mississippi, Missouri, North Carolina, Oklahoma, South Carolina, Tennessee, Texas, West Virginia. By the operation of Warren's opinion, every one of those statutes lost its constitutional foundation on June 12, 1967. Some would remain on the books for decades after, technically on paper, but none of them could ever again be enforced. A century of state racial gatekeeping over marriage ended in a unanimous opinion that ran fewer than 15 January of 1959, in a courtroom in Caroline County, Virginia, a state judge sentenced a married couple to a year in jail and then offered them a choice: serve the sentence or leave the state for 25 years. Their crime in the eyes of the Commonwealth of Virginia was the marriage itself. He was white, she was black. The judge wrote his reasoning into the record. These are his words: Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriage. The fact that he separated the races shows that he did not intend for the races to mix. The couple's name was Loving, and the question their case would carry to the Supreme Court of the United States was this: if a state judge can claim divine authority to criminalize a marriage, what is the 14th Amendment actually 1967, Mildred and Richard Loving went home. After nearly 9 years of exile in the District of Columbia, the Supreme Court had reversed their convictions. The Commonwealth of Virginia, a unanimous court, had ruled, never had the constitutional power to issue them in the first place. And it was not just Virginia. At the moment the court ruled, 15 other states still had anti-miscegenation laws on their books. By the close of that single afternoon in Washington, all 16 of them were dead letters. But the more lasting thing the court did that day was leave a sentence behind. Chief Justice Warren had written about marriage, and the words he chose were these: marriage is one of the basic civil rights of man, fundamental to our very existence and survival. He wrote that about Mildred Jeter, a black woman, and Richard Loving, a white man who had asked the United States Constitution to recognize their marriage. He did not write it only about them. He wrote it into the United States reports, where it has been waiting ever since for the next court that needed it.